The Supreme Court is hearing arguments today in a major case stemming from the January 6th attack on the Capitol. The outcome could invalidate felony obstruction charges for more than 300 people connected to the attack, including former President Trump. Senior Washington reporter Devin Dwyer joins me now for more on this. And Devin, you've been listening into these arguments all morning long. How is each side making their case?
Well, Stephanie, this case involves a law passed in the wake of the Enron scandal more than 20 years ago to prevent the destruction of evidence and financial documents. But prosecutors in those 300 cases and in the case against President Trump, as you mentioned, used this law to potentially send some of those alleged rioters behind bars for as much as 20 years. There's a provision in the Sarbanes-Oxley Act that says it is a crime to otherwise impede or interfere with an official proceeding. The government right now, Stephanie, is arguing that that is pretty broad language that applies to these rioters. They interfered with the counting of electoral votes. But one of the accused, Joseph Fisher, he's the man who brought this case. He has been charged with obstruction. He says really what Congress meant in this law was simply to penalize matters related to financial crimes and evidence, and that it was improperly used. The justices right now, Stephanie, are debating the language. This is a very textual case, and they're trying to figure out what exactly Congress meant when they wrote this, and can it be applied to these January 6 cases.
And how long could we see them discussing this for? When could the court issue a ruling?
Well, the ruling is expected by the end of the term, so just a couple months from now, the end of June. Those 300 cases that you talked about, all on the line here, those defendants could see reduced sentences if they've already pled guilty or been convicted. Some of the charges could be dropped in some of those cases, and one of the cases most closely watched, of course, is that of President Trump. Special counsel Jack Smith brought 4 charges against Donald Trump for his alleged election interference, and one of them was obstruction of an official proceeding brought under this very same financial evidence law from more than 20 years ago. So what the Supreme Court says about how that law can be applied could potentially also impact the president and whether that charge can go forward.
And while we have you, let's talk about a recent decision. Meanwhile, the court is allowing Idaho's ban on gender-affirming care for minors to be enforced. How significant is that, and what kind of immediate impact could we see?
Well, the Supreme Court yesterday morning did not weigh in on the merits of this case, Stephanie, but they did say that Idaho can begin enforcing this ban, a 10-year penalty, criminal penalty for any doctor that provides hormone therapy and the like to transgender kids under the age of 18. It is significant in that families seeking that care in Idaho will now be denied that care while this litigation continues. More than 20 states have laws that severely restrict this type of transitioning care. But on the other hand, the fight continues, Stephanie. The Supreme Court did allow the parents in this case to continue to seek care for their kids. It's a very narrow exception in Idaho with the expectation that they will hear this case at some point down the line. This is not the final word at the Supreme Court, Steph.
Senior Washington reporter Devin Dwyer. Thank you, Devin.
You bet.